All right. It is 6:30. I want to go ahead and get started. So hey, let me know in the chat if you can see me and see the slide and hear me. Somebody just put in the chat like yes or no so I can know what's going on. We're all good? Okay, good. So let's go ahead and get started. Welcome, welcome, welcome everyone to my back to school 10 things parents should know before celebrating webinar. So just in case you're wondering if you're in the right place, let's check. So if you have school age children or know someone who has children, you are in the right place. If you do not have children, but you're thinking of having children, you are in the right place. If you are at least 18 years old, you are in the right place. So let's go ahead and get started. So if you've been to my webinars, you know exactly how I love to start off with an inspirational quote. So quotes help me encourage myself when I need to be encouraged. So hopefully they do the same for you. So the quote for this one is, tell me and I forget. Teach me and I remember. Involve me and I learn. That's by Benjamin Franklin. All right. You should also know the next slide. What is that? My disclaimer. You can read it with me. I am an attorney licensed in Maryland and the District of Columbia. However, I am not your attorney unless my firm has an engagement letter signed by you or your agent and myself. So this webinar is for informational purposes only and does not constitute an attorney-client relationship. So now that we got that out the way, who is Michelle Bell? So I am a wife of 15 plus years. Somehow, some way, I found a man who's willing to deal with me and all my shenanigans, and it's been over 15 years. So kudos to him. His name is Derek. I don't know. It works somehow, right? So I'm a mother of 3 children. I have a daughter who's 23, and I have 2 boys, a 12-year-old and a 14-year-old. He just turned 14 last week. So I am an awesome daughter-in-law. Do you know why? Because my in-laws live with me. Like, I could do no wrong. I just can't. They live with me. It's 3 generations in this house. And we have a good time. Everybody's still alive, right? So I am a sports fanatic. I especially love baseball. That's something I enjoyed with my mom. So I love baseball, basketball, football. I don't know about golf, but a lot of the sports I'll watch too. I am the first lawyer in my family. I was born and raised in Brooklyn, New York. It is absolutely a blood type. If you've ever heard somebody say that, it is true. It's a blood type. It's more than just a location. And of course, I married a man that's from this area, so you can kind of know how that's going to go. You have New York teams, you have Maryland, D.C. area teams, same division and all these different sports. Yeah, you know how that is. So, started college at 17 years old. My mom passed when I was 15. Graduated high school at 16. Started college at 17, graduated at 20, and you'll see why it's not a great thing to name a minor as a beneficiary on some of your assets. You will see as we go through this. So, why are you here? To hang out with me and learn some things. So, estate planning is definitely not a one size fits all endeavor. Even if you think your particular situation is simple, that turns out to almost never be the case. To demonstrate just how complicated estate planning can be, here are 10 of the most common estate planning mistakes, starting with the worst blunder of all, failing to create an estate plan. So let's go ahead and jump right in. We're going to start off with number 10, not leaving an estate plan. If you die without an estate plan, the court will decide who inherits your assets, and this can lead to all sorts of problems. Who is entitled to your property is determined by your state's what they call intestate succession laws, which hinge largely upon whether you are married or if you have children. Spouses and children are given top priority, followed by your other closest living family members. So intestate just means you don't have, a will or something in place. So the state's estate plan for you kicks in. So technically you have an estate plan because the state gave you one. You just may not like it. So if you are single with no children, your assets typically go to your parents and siblings, and then more distant relatives if you have no living parents or siblings. So if no living relatives can be located, your assets go to the state. Assets are just another fancy word for stuff, right? So it's important to note that state intestacy laws, again, intestacy, you don't have a will or anything in place. So the state has laws for that. So it's important to note that the state intestacy laws only apply to blood relatives. So unmarried partners and close friends would get nothing. If you want someone outside of your family to inherit your assets, having a plan is an absolute must. If you're married with children and die with no plan, it might seem like things will go fairly smoothly, but that's not always the case. If you're married but have children from a previous relationship, your children could be left with nothing. So, in another example, you might be estranged from your kids or not trust them with money, but without a plan, state law controls who gets your assets, not you. Remember, they have a plan for you. You just may not like it. So, dying without a plan could also cause your surviving loved ones to get into like this ugly court battle over who has the most right to your property. Remember that saying, weddings and funerals bring out the worst in people? There's a reason they have that saying. It's true. So, if you become incapacitated, your loved ones could even get into conflict around your medical care. You may think this would never happen to your loved ones, but I see families torn apart all the time, even when there's not significant wealth involved. All right, so let's go to number 9. Thinking a will alone is enough. So lots of people, especially, my older generation, my seasoned folks, they believe that a will is the only estate planning tool they need. While a will is a fundamental part of nearly every adult's estate plan, which can ensure that your assets go where you want them to go in the event of your death, using a will by itself comes with like some serious limitations, including the following ones that I'm going to list. And you can see a summary of it on the slide. So, wills require your family to go to court process known as probate, which can not only be lengthy and expensive, it's also completely open to the public record, you deal with the court, and frequently creates ugly conflicts among your loved ones. So yes, only having a will, you will still go through the probate process. Wills don't offer you any protection if you become incapacitated by illness or injury. Incapacitation just means you're unable to make decisions for yourself. So if you become incapacitated by illness or injury or are unable to make your own medical, financial, or legal decisions, your will does not offer any protection for that. Wills don't cover jointly owned assets or those with beneficiary designations, such as life insurance policies and 401k plans. Wills don't provide any protection or guidance for when and how your heirs take control of their inheritance. Naming guardians for your minor children in your will can leave them vulnerable to being placed in the care of strangers. So, given these facts, if your estate plan consists of a will alone, you are missing out on many valuable safeguards for your assets, while also guaranteeing your family will have to go to court if you become incapacitated or when you die. Let your family grieve. Don't add court on top of it. So, with that said, as you'll see later, trusts are by no means a cure-all solution. These documents come with their own unique drawbacks, especially if you try to prepare one on your own. We all know about the DIY, things that you can pick up in some of these supply stores. We're not going to name them here, right? So let's go on to number 8, creating a trust and properly funding it. So they go hand in hand. You create it, that's great. You still have to fund it. Funded just means that you retitle your assets to go into the trust. Think of the trust as like this great stainless steel, wonderful, brand new bucket. Take it with you. It's great. There's nothing in it, so it's not protecting anything. You got to put stuff in it. So you want to take your toys with you. You want to take some food with you. You want to take fireworks, whatever you want to take, you put it in there. You take it with you. The bucket is protecting it. That's your trust. That's your assets. So many people now know that a trust can keep your family out of court. And you may think you can just go online and set up your own trust or have a lawyer do it with you as a one-size-fits-all solution. So, and while that might be true, particularly if you have very simple assets and few family members, even in that case, you are likely to overlook one of the most important parts of creating a trust. That is funding it. An unfunded trust is a trust that exists, but that doesn't hold any of your assets because you didn't retitle them properly or because you acquired new assets after creating your trust. This is all too common. And if this is true for you, it will leave your family with a big mess. It will, even though you have officially created your trust. So funding your trust properly is extremely important because if any assets are not properly funded, the trust won't work and your family will have to go to court in order to take ownership of that property. And when you acquire new assets after your trust is created, you must make sure those assets are properly funded into your trust as well. Bucket, put stuff in it, protect it, take it with you, right? All right, so let's go on to number 7. Leaving an up-to-date inventory of assets. Remember, assets, fancy word for stuff. So as previously mentioned in all our other points, even if you properly funded your assets into your trust, your estate plan will be worthless if your heirs don't know what you have or where to find it. In fact, there's more than $58 billion worth of lost assets in the U.S. Department of Unclaimed Property right now. And that's all because someone died or became incapacitated without letting anyone know how to locate their assets. So each state has an unclaimed property department. So this is one of the few times, and I will stress that few times, that I'm saying it's okay to be a Google lawyer and search for the amount of assets that are in your state's unclaimed property department. You all know how I feel about Google lawyers, but this is one of the few times I'm okay with it. So go check that out. Not right now, though, because we're in this webinar afterwards. So this is especially critical for digital assets like cryptocurrency, social media. Yes, that is a digital asset. Email and data stored in the cloud. Because if you haven't properly addressed these assets in your estate plan, there's a good chance they will be lost forever if something happens to you. For all of these reasons, creating and maintaining a comprehensive inventory of all of your assets should be a standard part of every estate plan. Your family has to know what you have to claim it. If not, the state will gladly take it. All right, we're on number 6. So, regularly review and update your estate plan. In addition to keeping an updated asset inventory, what we just talked about, it's vital that you regularly review and update all of your planning documents. So this happens a lot. People prepare a will or a trust, then they put it in a drawer on a shelf and they forget about it. This is not a rotisserie where you set it and forget it. That's not how this works. You have to review it. Life changes, your plan should change, right? So the estate plan is not a one and done deal. As time passes, your life circumstances change, the laws change, and your assets change. You must update your plan to reflect these changes. That is, if you want your plan to actually work for your loved ones and keep them out of court. So I absolutely recommend reviewing your plan annually or at least every 3 to 4 years to make sure its terms are up to date. And be sure to immediately update your planning following major life events like divorce, births, deaths, and inheritances. All right, we're at number 5. So, updating beneficiary designations. We're halfway there on the 10 things that you need to know before celebrating these kiddos going back to school. Hang in there with me. We're almost there, okay? So, in addition to reviewing and updating your core, excuse me. Whew. So, in addition to reviewing and updating your core estate planning documents like your will, your trust, your power of attorneys, it's crucial that you also update the documentation for your other assets. So, especially those with beneficiary designations. So, some of your most valuable assets, like your 401ks, IRAs, life insurance policies, they do not transfer via will or trust. Instead, these assets have beneficiary designations that allow you, excuse me, to name the person or persons you like to inherit the assets upon your death. So oftentimes people forget to change their beneficiary designations to match their estate planning goals, which can lead to what? Disasters. For example, if you get remarried and you forget to update your 401k, your ex-spouse from like 20 years ago, they could end up inheriting your retirement savings. It's probably not what you want to happen, but that will. You don't update them, that can happen. So some people assume that because they've named a specific heir as their beneficiary or their IRA in their will or trust, that there's no need to list the same person again as beneficiary in their IRA paperwork. So because of this, they leave the IRA beneficiary form blank or list my estate as the beneficiary. But this is like a major mistake and one that can lead to serious complications and expense for your loved ones. It makes no difference who is listed as a beneficiary in your will or trust. You must list the person you want to inherit the assets in the beneficiary designation, or your heirs will have to go to court to claim the assets. And of course, I'm going to stress this because I can't stress this enough, but just act like this is all caps, right? You should never name a minor child as a beneficiary of your life insurance or retirement accounts, even as the secondary beneficiary. If a child inherits assets, the assets become subject to control of the court until they reach the age of 18. And then the assets are distributed outright without any protection or direction. If you want a minor to inherit assets, you can create a special trust, excuse me, to hold the asset until the child comes of age. And name someone you trust to serve as a successor trustee to manage the assets until that is true. So, to give you a quick example, I'm that kid. My mom passed when I was 15. My mom named me, the minor, as a beneficiary to retirement accounts. I graduated high school at 16, wanted to go to college, applied, got in, didn't get full rides, but I could not access any of the assets or money that was left for me because I was underage. So I had to call my aunt who lived in Maryland and went to Bowie and worked at Bowie State University. I was a minor. My father signed over his rights. I went to her. I had to take a test, got into Bowie, a college I never heard of, university never heard of, never visited, never been to. So you took a city girl from Brooklyn, you dropped her in basically like the woods with something that had like last train. I don't even know what a last train is. Brooklyn, New York, we don't have a last train. It runs 24 hours. So that transition was crazy. So I am the product of what not to do. It took a while. I ended up at a college I didn't even want to go to. But it worked out. Met my husband and, we are where we are today. So let's go on to number 4, improper execution. You could have the best estate planning documents in the world, but if you fail to sign them or sign them improperly, they will fail. This might seem trivial, but we see it all the time. My team, all the time we see this. A loved one dies, their family brings their estate planning documents. We can't help them because the documents were either not signed or were signed improperly. So to be considered legally valid, certain estate planning documents like wills must be executed. And by executed, I mean they got to be signed, witnessed, and or notarized following very strict legal procedures. So it really depends on your state. For example, many states require that you and every witness to your will must sign it in the presence of one another. If your DIY service doesn't mention that condition, or you don't read the fine print and you fail to follow this procedure, the document can end up worthless. So, yes, you spent that money, spent that time filling it out, and it didn't help you at all. All right, we're coming down. We're at number 3, choosing the wrong executors or trustees. So, in addition to laws regarding execution, state laws are also very specific about who can serve in certain roles, like executor, trustee, or financial power of attorney. So, in some states, for instance, the executor of your will must either be a family member or an in law. And if not, the person you choose must live in the state. If your chosen executor doesn't meet those requirements, he or she cannot serve. And honestly, in some states, they actually require the person you name as your executor to get a bond, which is like kind of like an insurance policy before he or she can serve. So such bonds can be difficult to get for someone who has less than stellar credit score. You know, it happens to good people, but sometimes you just have bad credit scores. Things happen. So if your executor cannot get a bond, it will be up to the court to appoint your executor, which could end up being someone you would never want managing your assets, or a third-party professional who could drain your estate with costly fees. So please try to pick someone that you trust, someone that would have good credit score. You know, you don't want the court appointing someone because it may not be who you want, and they may not have the best interests at heart when they're doing these, when they are executing your trust. All right, so let's go on to number 2, unintended conflict between family members. We all know family dynamics are, how do you say it? Can be quite complex, right? So this is particularly true for blended families where spouses have children from previous relationships. If you try to go it alone using a DIY document service, you won't be able to consider all of the potential areas where conflict might arise among your family members and plan ahead to avoid such disputes. So after all, even the best set of documents will be unable to anticipate and navigate these complex emotional matters. So every day we do see families that end up in lifelong conflict due to poor estate planning. Yet we also see families brought closer together as a result of handling these matters the right way. So when done right, the estate planning process is actually a major opportunity to build new connections within your family. It looks good on TV. I know, the whole conflict, great for drama, great for ratings, not so great in real life. Does not go well and is not a good look. So we made it. We're at number 1. Can you guess what it is? Can you guess? Properly named guardians for minor children. I'm always preaching this. If you are a mom or dad with children under the age of 18 at home, your number 1 estate planning priority should be selecting and legally documenting both long and short-term guardians for your kids. Guardians are the people legally named to care for your children in the event something happens to you. So, quick tip. Naming godparents, that is not legally naming guardians for your kids. That is a spiritual matter, not a legal one, okay? So no, naming godparents is not what I'm talking about at all. If you've named guardians for your minor children in your will, even with the help of another lawyer, your kids could still be at risk of being taken into the care of strangers. So, for example, if you've named guardians for your kids in your will, what would happen if you became incapacitated and were no longer able to care for them? Did you know that your will only becomes effective in the event of your death? And it would do nothing to protect your children in the event of your incapacity. Because remember, when you're incapacitated, you're still alive. You just can't make decisions for yourself. You could be in a coma, or you could have a mental disease or issue like dementia, Alzheimer's. You can have all that stuff going on. You're still alive, right? So perhaps the guardians you named in your will, they live far away from your home. So it would take them several days to get there. If you haven't made legally binding arrangements, for the immediate care of your children, it's highly likely that they will be placed with the authorities until those guardians arrive. And you definitely don't want that. The kids are already going through craziness, like my parents are sick or my parents have died. You don't want to have them have to be in the custody of authorities. It's already scary enough for them. So, does anyone you name, do they know where your will is located and how to access it? How can they prove they are your children's legal guardians if they can't even find your estate plan? I have no idea why people hide these things, okay? People need to know where it is. How they know what's going to happen. You want them to tear up the whole house if something happened to you looking for it? Just let people know where it is. So these are just a few of the potential complications that can arise when naming legal guardians for your kids, whether in your will or as a standalone measure. And if just one of these contingencies were to occur, your children will more than likely be placed in the care of strangers. So I have a favor to ask. Now that you done hung in there with me for the 10 things parents should know before they start celebrating these kiddos going back to school and you get your time back, right? So here's my favor. I'm actually looking for introductions to private school counselors, tutors, and PTA board members. If you know any, please, please, please introduce us. I really feel like these are things that the information I gave you today, hopefully it was valuable to you. I think other parents need to hear this. And the best way to do that is to introduce them to me. I promise you, my energy that you get right now, it's like level 10 when I actually present in real life. Can you imagine? So I will do you a solid. I will definitely represent you well. I will give the information. It will be wonderful. Please, please, please introduce me to private school counselors, tutors, and PTAs. You can have them call me, email me. It'd be great. Now, you can also have a one-to-one session with me where we can talk a little bit more. If you saw yourself in one of these points, you're like, oh my goodness, I don't have this. I need this. I'm not sure what to do. Michelle, we're a blended family. Or Michelle, I do have a child, or I don't have kids. I thought my spouse would get everything. Those questions, absolutely. Go ahead and give me a call, email me, and we can talk about it. All right? All right. So we have 3 minutes. Let's go. Let's get this Q&A going. Any questions? Any questions? I do have 2 screens. So if you see me looking off, it's because I'm looking at one screen. But I used to. The tech is real in here. Ooh, let me see. I thought those were things that were like set it and forget it. I love it. That was like one of the best commercials. Let me see. Funding a trust means putting items into the trust like a house and not money, right? Or do you put money in there as well? Great question. Great question. So there are different ways that you can do it. You retitle the deed to your home. That goes into the bucket, right? So that goes into the trust. When it comes to retirement accounts, what I normally have people do is they list the trust as a contingent beneficiary. So they have their beneficiaries, because remember that it doesn't matter what your will or trust says, the beneficiary gets it. I usually have them list the trust as a contingent beneficiary. That way there's always something there to catch it. Life insurance, same thing. Bank accounts where your money is, you can list your trust as a pay on death beneficiary. Okay? You don't have to put the accounts in the trust name. You can do it as pay on death beneficiary. However, there are attorneys that will advise different way. That doesn't mean they're wrong. You have to look at it this way. You have good, better, best. So what's a good way to do it? What's a better way to do it? What's the best way to do it? So I find that sometimes working with banks, some of the employees may not understand how trusts are set up, how to handle trust and accounts. So if you just list the trust as a pay on death beneficiary, that usually happens a lot quicker and it's less painful for your client, as well as, the bankers and the attorney who now has to explain everything, and hopefully people understand. Those were great questions. We have about a minute left. Anybody else? Let me see. How do you put digital assets in a trust, such as social media account or items stored in the cloud? So in your trust, you can assign the interest to those things or assign them in your trust and say, hey, these are mine. These are who get to take it over and will be the beneficiary to those items. Last question. If you don't update your beneficiary designations, the 20-year ago X, for example, does the new spouse just have to deal with it, or can they fight that designation? Unfortunately, the X gets it. They get to keep it. Remember, designations, they trump what's in your will and in your trust. Now, the new spouse can go ahead and try to fight it, but don't forget, a trust is private. So it doesn't even get filed with the court. So that can be an issue. If you only have a will, you have to go through the court. But that new spouse, that may be an uphill battle because not all assets go through the court process. So if there's a beneficiary listed, it's not even considered probate. So it wouldn't even go through the court process. So basically, the new spouse is just going to be angry. And they're so angry at you, but you've passed away. I mean, what are they going to do? So it's unfortunate. So definitely review all your beneficiaries, review your assets. This is not a set it and forget it type thing. Anything else? No. I'm only 1 minute over. Yay! So this was awesome. I appreciate it. Thank you for coming. Have a great evening.